Minority shareholders may have been given new leverage to derail investment rounds using one of the most popular investment templates. But don't worry, there is a fix available. And in this video, I'll explain to you what the issue is and what the potential fix is. The UK Court of Appeal has recently held that a mechanism to automatically convert shares was not as automatic as we all thought, and in fact it required a particular type of class consent. On its face, this decision is surprising and concerning. Surprising because the text in this case appeared to be relatively clear and unambiguous, talking about an automatic conversion without the need for further authority. Concerning because the clause on which the court was ruling is based on one of the most popular templates used for investment documents published by the BVCA. This means there's a real possibility that your business may have taken investment on terms using these template clauses. So what is the specific issue that the court was looking at? The company in this case created a new class of Series A share. The clause dealing with the Series A shares said that they would automatically convert without further authority if a notice was received. There was another clause of general application in the Constitution that said no rights attaching to any shares could be varied without a particular type of consent. Now, you might be forgiven for thinking that the clear language about an automatic conversion meant the parties thought there was no need to get any further consent. But the court did not agree, and because the clauses didn't cross-reference each other, that was the fatal issue in this case. So the court did point to a fix. So what is this fix, and what do you need to be aware of? So, if your constitution contains a mechanism to automatically convert shares, you need to check if that mechanism expressly excludes a requirement for class consent. If that mechanism does not exclude a requirement for class consent, you should consider adding it now. Or, if you are a minority investor and you have been involved in an investment round without your consent, you might want to check those investment documents to see if you have a basis to challenge that ground on the basis that your consent was not obtained.